Welcome to this lecture episode on this YouTube platform. As usual, it is about nurturing our mind with issues that matter when it comes to law and justice and what we need specifically to know, especially when we refer ourselves to certain terminologies, concepts, and words that people use interchangeably and the meaning disappearing with time. Today's topic, however, is the concept of family and the family law and its challenges today in the Republic of Kenya. I would like to admit that the world is changing. Times are changing. What was then is not what is now. We also admit the following, that going back in time, using the time machine would also help us as a guiding principle to put our argument straight and make certain allegations clearer than what one may imagine. In Kenya, what is family can be understood within what the Constitution of 2010 defines under Article 45. The Constitution defines family as follows, quote, "Family is the natural and fundamental unit of the society and a necessary basis for social order, and for this, the state shall recognize and protect the family." This brings us to the definition of the family according to the Kenyan Constitution. Marriage Act of 2014 defines marriage as follows, quote, "Marriage is the voluntary union between a man and a woman." However, still, when we talk about family law, and what is family, it is important that we get to know that family is about relations and relationships that are created out of agreements. We have relationship between the married couple or the couple, man and a woman, and also the relationship with children and siblings. But in the African context, it is extended family in the sense of the kins, the relatives of the husband and the relatives of the wife. They all cluster together into the concept of the extended family. This is something peculiar in the African customary law and the African traditions and customs that need our attention whenever we address ourselves to the concept of the family, especially in Kenya today. However, still we need to admit certain realities that have changed over time. The question of family is not only legal, but it is also sacrosanct within the African communities to an extent that addressing oneself to family becomes something that is very important because it is the smallest unit and the fundamental unit of the society. But how about a natural unit? What do we refer to as natural as opposed to unnatural or artificial? Well, this is from the principle and the concept that is founded within the natural order of things. This is within the cosmic law or the order in which things happen without human interference. Well, keeping it at that level, when we say family is natural and fundamental unit, we need to understand that it involves the order of nature, in which only a man and a woman can get into voluntary union in marriage and form a family. And in that matter, such family is protected by the state. However, still, how about other rights such as the gay marriages? How about the rights of the lesbians or the questions of the fundamental freedom and equality principle in the human rights? And the Bill of Rights is clear under Article 27 that there is equality of rights and fundamental freedoms for all citizens. Article number 1 puts to us this problem, the sovereignty of the people. If we say the people are sovereign, who are the people? The people, I presume, includes the communities and ethnic groups and individuals. In that case, people who belong to the LGBT are also considered within the framework of the Constitution. The same tragedy and risk founded within the supreme law, the Constitution, is under Article 2, sub-article 5 and 6, that includes the general principles of the international law, as well as the treaties and conventions ratified by Kenya as part of the laws of Kenya. And this is constitutional, making Kenya a monist state rather than a dualist state. Is Kenya still justified to stick to the definition of the family as the union between a man and a woman? Is it still making sense and applying to the international treaties when this leaves out gay marriages? Within the quotation of the Constitution and the quotation of the Marriage Act and other acts in Kenya, including Children Act, Kenya is perfectly justified to take its stand when it comes to certain principles and international policies that are enforced by the international community. But Kenya is not under any obligation whatsoever to subject itself maybe to certain practices that the people themselves may not agree to. Still, I save the point of the definition of the people. Who are the people? They are the citizens. And these citizens have got equal share when it comes to rights and obligations. And they are equal before the law and justice. The question of interpretation of the family and the family law, which is vast and is about relationships, is taking us back to another problem. The problem of the dichotomy. We have the dichotomy in this country. The dichotomy between the state law, that is the formal and enforced, articulated state law, known as the laws of Kenya that are in writing, beginning with the Constitution, then the Acts of Parliament, then the international treaties. And another system is that known as customary. So customary versus statutory. And in this case, we find two parallel systems seeking to find coherence in one legal system known as Kenyan legal system. This is where we proudly say that the African customary law and its principles and values being upheld by, quote unquote, the African communities or ethnic groups that in their diversities have got certain practices and beliefs that may not be wished away, not very soon, as I can testify in this lecture. Kenya had got a wrong beginning when at the independence, when the Kenyan government replaced the British government, things were not well worked, in the sense that the lacuna or the gap that had been there between the British law and the African law was not breached. The British ruled Kenya using their administrators, who were the British, and they were the administrative officials. The district commissioners and officers were all the British. Later on, some Indians were as well employed to serve in that capacity. However, still, the British and the Indians could not apprehend the holistic nature of the African customary law, nor the African jurisprudence, nor the African law. By not understanding that, or withstanding whatever was unfolding, the British government decided to use divide and rule. This segregation left the Africans in their areas that were like the reserves. And such areas, people were living and applying their African customary law without any interference whatsoever. Simply because of failure to understand such concepts as what is family for the Africans and what is the African understanding of justice. How do the African practice their law and what is their law? How do the Africans come up with adjudication processes? Having this kind of difficulty, the British decided to form a segregated kind of system in which the Africans on themselves and the British on themselves. However, certain matters will be taken to the district officers, but without proper and appropriate outcome. And that would again push it back to the communities. The British decided to rule by proxies, and this is seen in the appointment of paramount chiefs. Paramount chiefs became unpopular because they were like spies of the British government, the colonial government, whose regime was already being criticized and was losing favor among the Africans because of the war of liberation for the country. Later on, at the independence, the first government did not have that interest of promoting and developing the African courts that had already been abolished, the customary courts. And in that case, matters ended up to the chiefs, whose reputation was already tainted. This is the reason for which the customary law is getting day by day more robust, and Africans are resisting things or practices that they do consider not of value, their vices. They cannot easily endorse such things like gay marriages, or maybe lesbian marriages, or LGBT in its totality, because that is still not only found to be peculiar to the natural order, but also against the morality as per the standards of the Africans. This is where the problem lies, and this is where the definition of the family by the Kenyan constitution is still very valid and legitimate and accepted, despite the fact that Kenya has made itself a mono-state rather than a dual state by including the international law within its constitution as the sources of law in the Republic of Kenya. However, still, the debate is out there. This is not absolutely a final conclusion. But remember that even today, many Africans still may not have the courage, or they may not be bold enough to take their brothers to the state courts, to the formal courts for adjudication. Why? Ask yourself. The reason being, there are certain practices that Africans have not completely endorsed as value for them, as principles for them. And we are not justified, or any authority is not justified to force them to accept and endorse such practices. Simply because the same international treaty, the Convention of 2007, United Nations Declaration on the indigenous rights of the populations, it is still holding, and the culture of the people is sacrosanct, and no authority should be seen to go in violation or to infringe those rights as we know them today. So it is a debate, it is out there. You can share your thoughts about the family definition, and I am more than happy to read your comments and your contributions. Bye for today, and Peter here, University of Nairobi School of Law, Kisumu Campus.